Welcome to Solving Citizen Legal Encounters. All right, we have an interesting case today of a landlord-tenant dispute, but it's going to have a little twist to it. And the attorney in the case is pro se. So we're going to go into this hearing right after this commercial. Before we get started, today's sponsor is Aura, and I'm going to show you why I use them to protect my data and my computer. Aura is an all-in-one digital solution that gives me peace of mind online. It protects my personal information, secures my devices with antivirus and VPN, and even scrubs my data off broker sites automatically. Data brokers collect your personal details, bundle them into profiles, and sell them to marketers, scammers, and even stalkers, all without your permission. Data brokers are required legally to remove your information when you ask, but they make the process so confusing and time-consuming, most people give up. That's why I use Aura. They automatically submit removal requests to those sites and follow up to keep your data off. And one of the greatest points that I see is that they have parental control to manage your kids' screen time and get alerts about risky behavior. All of it in one app. Try Aura for free for 14 days by going to aura.com/Sovereign Citizen Encounters or click the link in the description.
So we're going to begin then with the first case on the docket is causing in an 806, Sarah M. Braun, Brian Petrie versus Mark Cohen. I see the parties are here. If you'll unmute yourselves, please.
Good morning, Your Honor.
Good morning. All right. So if you all like, I don't know if you've had the opportunity to talk about this case. Would you like to go into a private breakout room to discuss a little bit before we get started?
We're prepared to present the case now.
Okay. If I can have the parties then, please raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right. So what I'm going to do is I have read the complaint. I've read the counterclaim. If Mr. Peachy or Ms. Braun, either one of you can give a really short 30-second introduction. You don't have to give me all the facts of the case, just basically why you're here. And then Mr. Cohen, I'll give you the opportunity to do the same.
Thank you, Your Honor. We're grateful for the opportunity to present our case. The facts of this case are pretty straightforward. We rented a house from Mr. Cohen for 18 months. After notifying Mr. Cohen of our intent to vacate within the requisite time period, he hired a landscaping crew to perform extensive work on the property, work that was done a full month before our move-out date and without any prior notice to us. This included decorative landscaping upgrades, which he then deducted from our security deposit.
Mr. Cohen?
Yes, Your Honor. I did do repairs to the landscaping, which I was allowed to do under the lease. And when you see the photographs between what I delivered to them when they moved in and what it looked like 3 weeks before they were moving out, you'll see that what I did was reasonable and I spent way over their security deposit, only kept the security deposit, didn't even ask them for the rest of it until they sued me.
Okay. All right. So Mr. Petrie, would you like to call any witnesses to get started? Or do you want to just go ahead and proceed and give me a basically the facts of the case for you to be the witness if that's the case?
We'd like just to proceed with the facts of the case. We've got a number of exhibits and evidence that we'll reference, including photographs.
All right. Well, you've been sworn in, so I will treat your statement as your testimony.
Again, thank you for the opportunity to present our case. I think there are 3 ways in which to view the defendant's actions. First, the defendant's claims for damages did not meet the requirement to itemize all damages and related expenses, as his letter to us claims damages that were not reflected in any invoice. Second, Mr. Cohen did not provide the least required notice to us when the landscaping crew arrived to do the decorative landscaping. The least required reasonable advance notice, he arrived and knocked on our door. This landscaping upgrades are not in response to any damages. In any event, they were done while we were still in possession of the property and don't constitute wear and tear. And finally, the defendant's course of conduct during the term of the lease demonstrates bad faith, as he never intended to return our security deposit at the time we moved out. The first and easiest way to view this case is simply by looking at the nature of the rejection of our security deposit at Exhibit 1. So I'd like to draw your attention to Exhibit 1.
And admit that into evidence.
Okay, they sound like tag team attorneys.
Well, can you pull it up on your screen, share the screen?
Sure, absolutely. Let's see if I can do that.
We did send this via email also to you.
But I do have it all up. Let's see. Sorry, this is
And I just allowed access. So over the share, it should let you click on it.
okay. So, oops. Let's see. Share. And here we go. Okay. Are you able to see this this evidence here, or it's
Yes,
probably too small? Is it too small?
it is small. If you can raise it a little bit more. There you go. That's fine.
Okay, so you can see this is the letter that Mr. Cohen delivered to us when we moved out. He said he was shocked to see the condition of the yard. The hillscape had to be re-landscaped. He cited a few damages, including a dead bush and some removal of shelves. But you can see what he then included for his damages, which are $8,000 of decorative landscaping upgrades. So the first item is cleaning up of flower beds. Again, we were living in the property at the time. So he's charging us for cleanup of property for a property we were already living in without any prior notice to us. So that's
It was on January 15th, a
So
full month before.
Ms. Braun, hold on. Just one person. You'll be able to testify in a moment.
yeah. So as my wife was saying, this was January 15th. These services were done, and it was a full month before we moved out. So he's charging us for cleanup of the house we were already living in. Then
What date did you move out?
I'm sorry, we moved
What
out
day
February
did you move out?
15th.
I'm sorry, say that again.
February 15th.
So February 15th was move out date.
Yes, sir. And this was work he showed up with the landscaping crew and did on January 15th. And the slope that he cites is for somehow that we've caused damage to. Again, it's a 45-degree slope on the property, which you'll see in the photos. There was mulch and a weed barrier in that location, but because the slope is probably 45 degrees in that spot, it obviously didn't hold. So he decided instead of using mulch and river rock or mulch to install new river rock. That was a decorative landscaping upgrade that again he's billing us for. That's number 2 on the list. Then he installed new weed barrier. That's the $700. He installed black steel metal edging on the property, which did not exist before, to retain the river rocks. And again, this totaled $8,250. So this constitutes the bulk of what he's charging us for the deduction of the security deposit. And this also constitutes his countersuit to us for $3,000 additional dollars. So he wants us to pay for his landscaping upgrades. This is the hillside in question, and this is the photo he took. Obviously, we don't have any photos from January 15th.
So let's go back a second. Are you admitting the letter with the invoice as evidence?
Yes, sir.
All right. Mr. Cohen, any objection to that?
No, Your Honor.
All right. So the letter with the attached invoice will be Exhibit 1. All right. So let's go on to this photo now.
Yeah, this is the photo that Mr. Cohen provided to us when he denied our security deposit. My guess is this is a photo he took when he arrived with the landscaping crew. You can ask him when he took it. But this is what he's claiming to show the damages. This is the slope of the hill. I mean, it's too steep for anyone to walk on, and you can see some of the mulch is slid off. But this is what he had now re-landscaped with river rocks and black metal edging and billed us for.
All right. Mr. Cohen, any objection to this photograph being entered into evidence?
No, Your Honor.
All right. It'll be entered then.
And then finally, in the invoice, you'll see some additional work that was done. Again, this is not itemized. You can see there's one total for $378. It includes 4 line items that are not itemized according to the code. One of which is to silicone the shower. Mr. Cohen again claims that we had a moldy shower. We honestly battled that shower the entire 18 months we lived there because the grout had not been sealed, and we had maid service twice a month to clean it. We included bleach, every other week to clean the shower, and he again re-siliconed the shower and then billed us for that. We did have one shelf that was in the house that we did not take off, and he billed us for that. And then also haul off, which I don't know what that is. That could be material that was there when we moved in. There was quite a number of things in the back that were there when we moved in. So again, it's not itemized, and there's no information there as to what that looks like.
All right. And you're wishing to submit this into evidence?
Yes, sir.
All right. Mr. Cohen, any objection?
No, Your Honor, that was an attachment to the first exhibit.
Okay, so this is part of the original invoices that go with that letter, is that correct?
That's correct. This one and the other invoice for the landscaping company were attached to the letter.
So we'll consider this as part of Exhibit 1 then.
That's correct.
All right, you may proceed, Mr. Petrie.
Thank you. So as I was mentioning, there's a number of ways to view the case. The first was that I'm sorry, I didn't find my again, as you'll see through those exhibits, that Mr. Cohen was billing us for decorative landscaping upgrades, and he did not include the required details. And you'll see that that the example for haul off was there was no detail in that service. The next way to understand this case is that Mr. Cohen is claiming normal wear and tear damages. I can fully understand why the weed barrier and mulch that Mr. Cohen originally installed on his 45-degree hillside did not work, and why he decided to install river rocks and steel edging. This is not a part of the property that can even be walked on because it's so steep. I'm not sure what type of damage he's claiming that we did to this property other than the wear and tear of the slope.
Sounds to me he's just trying to get some free upgrades.
It's also not the portion that he's taking a picture of is not irrigated, so there was no way to irrigate that portion of the property. And also these pictures were taken in January after a freeze. I can almost also understand why he'd want to do improvements a month before he moved out in order to show the house. What I don't understand is why he felt compelled to later bill us for this work. Frankly, the house was in pretty terrible condition when we moved in. What we have is Exhibit 2 of the lease condition form, and I can share that as well. And it lists all of the problems in the house. And I'd like you to draw your attention to that exhibit. Should I share that as well? All right, let's see if you can.
You see that?
I might
Yes.
She's itching to talk.
So Exhibit 2 is the lease condition form. And this is what we filled out when we moved into the house. And you can see on Exhibit A, on the first page here, it says that the backyard was overgrown and there's spotty brown grass in the front. Mr. Cohen is claiming that we killed his grass, but honestly, the grass was mostly weeds and brown. We moved in as evidenced by this lease condition. Additionally, there was in the back a giant vine that had killed one of the trees. I think that's one of the things he's claiming had to be hauled away, was this dead tree that was in the overgrown backyard. But again, that was evident when we moved in as shown in this lease condition report. I'll just scroll through here and show you, generally the rest of the comments that we've made on the house. The house was a 35-year-old house. It did not have many upgrades in it. And again, we rented what we thought as a fair price, but not one that we felt we needed to spend money to upgrade all of these. So you can see just the quite number of damages that were existing on the property.
I notice in a lot of these cases that people tend to do inspections on the house after they move in. I thought you're supposed to do inspections before you move in.
And the date here again is August 20th,
2023.
2023. This is when we moved in.
All right, Mr. Cohen, any objections to this being admitted into evidence?
No, Your Honor.
Okay, it'll be admitted.
I can stop it for you. Oh, you got it. Okay.
Okay, thank you. Sorry. I had put them all in different exhibits, so it's a lot of tabs to go through. Just continuing, again, the grass was overgrown. There were a number of things that needed repair in the house. And, as any resident in Austin can tell you, the Austin weather is challenging. We went through intense heat, drought, and freeze cycles during 2023 to 2025. There was really only one bush that had died in the freeze shortly before we moved out. Unfortunately, I can't show you pictures because, again, Mr. Cohen removed all of these bushes without any notice to us on January 15th. Additionally, we were never given the opportunity to do any trimming or basic upkeep prior to our move-out date and prior to the damages that Mr. Cohen has claimed that we've done. Um, Additionally, Mr. Cohen, through the entirety of our time renting, has claimed that we had owed some additional enhanced repair obligations under the lease. He actually submitted as in his the court filing a lease that was subsequently amended, and I'll show you as amended, if you don't mind, the repair requirements of the lease, if that would be helpful.
Go ahead and, I mean, this is your case, so you need to present to me the things that you wish me to consider.
Sure, let me just share that. Okay, so am I sharing the lease exhibit 4?
No.
So this is the amended lease, and this is what's showing the lease obligations for repair. So when we moved into the house, we signed a lease, and Mr. Cohen had claimed that lease required us to repair everything in the property, including an air conditioner that had stopped working. Eventually, we said we weren't going to pay for it, so he paid for the repairs. But in June 2024, we provided notice to vacate because we couldn't live under these repair obligations that Mr. Cohen were claiming. For example, if the roof were to fail or the air conditioner were to go out, Mr. Cohen was claiming we'd have to repair that. So we amended the lease in July 2025 to extend the lease for 6 months. And that was the only way we were going to agree to stay, to avoid some of those repair obligations that Mr. Cohen was trying to say we owed. And in this section, it shows, I'll show you where we're required to pay for damages. So on section 8, the paragraph 8, section 7, this is really the relevant provision, that any damage caused in whole or in part by the negligence in the maintenance of the yard. So we really have a negligence standard for the yard, which again, on a 45-degree slope, I'm not sure what he's claiming we did that was negligent. It was really the, kind of the slope of the hill that's causing the disrepair. And again, some weather challenges that we had during the term of the lease. And then finally, the third way I think to see this case is that Mr. Cohen has dealt with us in bad faith from the time we moved in. The pest service we hired found that rodents had chewed through the fascia and had a hole in the outside, and one of the ACs was not working. And while citing the amended lease repair provisions, Mr. Cohen reluctantly agreed to fix the AC, but noted that we were responsible for all future repairs.
They would have been better off buying their own house.
I'd like to reference Exhibit 5, which has the...
Well, let's go back now, that since we're going to a different exhibit. Mr. Cohen, any objection to the exhibit to the amended lease?
To the amendment to the lease? No, I have no objection to that.
Okay, so that'll be entered. All right, go on to the next point then, Mr. Petrie.
So I'd like to show Exhibit 5, which has the correspondence. Let me again share that screen here. Let's see if this is correct. Okay.
Due to some of the personal information on the forms, I have to blur out the information, but he's going to explain exactly what's on those papers that he's going to show. So you just had to bear with this part. Thank you.
So this is Exhibit 5 correspondence. And so you want to reference a couple of the sections. So this is what we were dealing with in June 2027. Again, as I mentioned, that we wanted to move out of the house because of the repair obligations that Mr. Cohen were saying we owed on the house. He said he had set the price low and relieved himself of repairs, and that's what he was claiming on the lease, that he didn't have to repair anything. As you can see, we had said, in September 2027 or December 27th, 2023, that we wanted to bring attention to the rats causing the damage. And again, he's saying that, he said that he had rats a few years ago and you leased as is and agreed to take care of all maintenance. So again, he's during the time of the lease, he's saying that we owed everything from, rodent damage from the time we moved in to broken ACs, et cetera, and citing the lease provisions. Also, wanted to show you some of the bad faith that he showed. There was a couple of instances where, it's very clear that he um, you want to mention the fan? I'm sorry,
I don't
Sarah.
know if I can. Can I jump in here?
Not yet.
Okay. So another instance that was on page 3, uh, Mr. Cohen, there was a 30-year-old ceiling fan that had caught on fire, and we'd asked Mr. Cohen to replace that. I know it's a bit hard to read here.
Increase it. Just there. Plus.
That he said that he conferred with this is from the property manager, conferred with Mr. Cohen, and that he's sticking to the lease agreement where we're responsible for all repairs, and it was agreed in return for lower rent, which we never agreed to a lower rent. We paid the market listing price, and the ceiling fan undoubtedly needs repair, and it would need a new light or replacement. You may use any vendor you like. We again pushed back. Ultimately, the fan was repaired, but you can see the dealings we had with Mr. Cohen throughout the entirety of the lease was that where the house almost caught on fire and he refused to replace the ceiling fan. Later on, when we decided to move out and trying to get our security deposit back, he noted a couple of things. He said on, let's see, on page 4, he said that in this email to us, he said, "I'm truly sorry, but I believe you can't expect me to pay $10,000 to bring my yard and home back to rentable condition." So he's clearly, from his correspondence, this is, a money-making venture for him, and obviously he's renting his house, and he doesn't want to pay any repairs to the house, even those that are just due to normal wear and tear. And then, when we sought to get our security deposit back, he did say that, see, this was on page 8.
The very top.
He did say that he tried real estate disputes for over 50 years and carefully drafted the lease, and that he can't just take $6,000 landscaping hit. So he's, with the delivery of the rejection of our security deposit on the law firm stationery, including, threats of counterclaims, that, he's clearly been intimidating us from the beginning that, we were going to find this day where, he's done all this repair work and threatened to sue us if we tried to get the money back.
I can say he's doing a really good job of presenting this case.
And then finally, I'd like just to show a few photos, if that's okay.
So real quick, hold on,
All
Mr. Cohen, any objection to this string of emails being entered into evidence?
No, Your Honor.
All right, they'll be entered. All right, go ahead.
So finally, I have Exhibit 6, which are a few photos. Again, we've been talking a lot about the yard. So this is a photo from 2 weeks after we moved in. This is my son who caught a snake in the yard, and you can see, the brown patchy grass. There's Bermuda grass here. This was mostly horseherd weeds, and some Bermuda grass that had died here. This is when we had moved in. You can see the bushes are quite overgrown. This is what the house looked like when we moved in. So I'm not sure what pristine look he's saying this house was in. This was the listing in May of 2023. Again, several months before, but you can see there are no river rocks or metal edging here. This was all landscaping upgrades he did later.
Probably from the previous tenant's security deposit.
And this was the week after the landscaping work was done, and you can see we still had continuing, frost and freeze during that time. So, it was a very challenging, weather conditions when we moved out. These are photos that we took when we moved out. So this is again what the yard looked like when we moved out. I mean, you can see the river rocks he's now included, in addition where there used to be mulch, which we were billed for. And then there's also metal edging on the bottom as well. But you can see the grass looks, virtually the same as when we moved out, when we moved in. Here's when we moved out in the backyard. You can see we cleaned up, all the debris from the backyard. I'm not sure what he's claiming is haul off. This is again pictures when we moved out. We left, honestly, the house in pristine condition. We paid to have the carpet steam cleaned. We had, again, professional cleaning 2 times a month.
Look at that.
and I bought a pressure washer to pressure wash all the driveway. I mean, we put so much effort into this just to kind of get told that, we treated the house poorly. It's a bit much. This is again the living room we moved out. You can see, sparkling. I mean, we had professionals clean. We spent 2 days scrubbing this house inside and out. But I guess it doesn't matter when you bill for damages done before you moved out. And this is the shower that again was claimed as part of the security deposit. You can see this is the condition picture we took when we moved out. There is some mold under the silicone, but I mean we did our best to clean it during the time we were there. There just wasn't a lot of ventilation, and the grout had probably not been sealed. So in conclusion, the Texas Property Code requires that Section 92-109 that the landlord that does not provide a written description and itemized list of damages and charges forfeits his right to withhold a portion of the security deposit and is liable for attorney's fees and recovering damages. So there's treble damages for bad faith, and I think we've shown through this case that Mr. Cohen never intended to pay us our security deposit. He had decorative landscaping done before we moved out, and then was charging us for, again, normal wear and tear, and never itemized the materials on the rejection of our security deposit.
All right. Anything else from you, Mr. Petrie?
No, Your Honor.
Mr. Cohen, do you have any questions for Mr. Petrie?
No, Your Honor.
I'm sure he doesn't have anything to say after Mr. Petrie dished out that defense.
Ms. Braun, you wanted to speak?
Yes, Your Honor. So,
No, hold on. Ms. Braun, they still have the
yeah,
case.
no,
So,
I'm sorry.
Ms. Braun, is there anything that you wish to add, or is it pretty much all covered?
It's pretty much all covered. I think, under Property Code Section 92.104, subsection C, he's required to give us a written description and itemized list of deductions from the security deposit. He didn't do that. It was simply an invoice. And furthermore, that work was done a full month before we moved out. He, showed up at our door unannounced on January 15th with a landscaping crew. I was on a work call. I answered the door. He said, "Hello, I'm here with my landscaping crew who's going to be doing measurements and work." He didn't ask me. He told me. And they proceeded to do that work. So that was done, and that is what he's now claiming damages against us for. And so, I think it's pretty simple that he didn't follow the law.
Didn't the husband just cover all that?
Mr. Cohen, any questions for Ms. Braun?
No, Your Honor.
All right. Mr. Petrie, anything else?
No, Your Honor. Thanks for the opportunity to present my case.
All right. Mr. Cohen, you may proceed.
Okay, Your Honor, let me give you a little background. I lived in this house for 33 years with my wife that I've been married to for 52 years. She died in 2022 from cancer, and I stayed in the house, but I found myself crying every single day. So I wanted to stay in the house, but someone said, well, maybe it's the fact that your wife's stuff's all around and all her energy's in the house. So that's when I decided to move out. I was going to charge $5,000 a month, and really didn't get a lot of quick bites on that price. So
Let me ask you, what's the square footage of the home?
about 3,000.
And where is it located?
It's in Rollingwood on Pleasant Drive.
All right, go ahead.
All right. So I lowered it to 4,800, but I drafted a lease, and like I said, I've been a lawyer for 52 years. I've been litigating and drafting real estate and business documents, and I litigated criminal cases, and so I drafted a lease, and that but the first thing I want to do is show you Exhibit 9. I don't know how exactly I'm going to share this, but let me see if I can figure it out.
Well, and if you scroll the cursor, you'll see the green arrow where it says share. Just hit that, and that'll be able to get you
So that gets me to where?
That'll get you to share your screen, what's on your screen.
Okay. So I need to get that open then first, right? Is that it?
So Brashay, does he have access to share? Yes.
Yeah.
So just hit that button,
Yes, sir.
and then you can open up the file that you wish us to see.
Okay.
And it'll ask you like what do you want to share. So you'll just click on whichever screen you want to share.
He definitely hasn't been in Zoom court in a while.
Oh, okay. Well, let's see. Whew. Um, all right. So this is going to be a problem for me because all of my, let's see. Wow, I didn't do this right. So all of my exhibits are in my office email and I'm on my laptop. So let me, if you'll just give me a minute to work this out, I'll have to go to my office email and have that all that stuff mailed to the other one. Let's see.
So basically, he has nothing ready for court.
Here we go. Okay. Open.
While you're looking for that, Mr. Petrie, I never did get the amount of the deposit that you're seeking.
Your Honor, it was $4,800,
All right.
Oh
which was
boy.
the initial lease.
Let's see. How am I going to do this?
For a second, I thought I heard someone in the restroom.
Okay.
And I saw also that you're suing for more, which is the amount of the treble damages. Is that correct?
Yes, Your Honor. I'm suing for the amount of treble damages minus the $350, which was I didn't include in the treble damages, which was the second invoice because I didn't view that in bad faith because that service was performed after we moved out, but where the landscaping work was, I thought clearly in bad faith and done before we moved out. So I trebled that portion of the lease, as well as $100 plus costs.
All right, Mr. Cohen, you're on mute. Mr. Cohen, you're on mute. I can't hear you. Mr. Cohen, you're on mute. I cannot hear you. Mr. Cohen, you're on mute. Mr. Cohen, stop talking. Mr. Cohen, you're on mute. We cannot hear anything you're saying. Brichet, are you able to unmute him?
I'm not, Your Honor. Mr. Cohen, I have hit the button to unmute you. If you can pull open your Zoom and hit that again for me.
Mr. Cohen, please stop. Send him a message.
Okay.
This is absolutely ridiculous.
Mr. Cohen, you have to stop. Mr. Cohen, you are on mute. Please unmute yourself. Mr. Cohen.
All right.
So
Sorry.
we didn't
we
hear
go.
anything that you said, Mr. Cohen.
Okay. So you didn't hear anything I ever said?
Nothing.
Okay.
Nothing. You were on mute the entire time.
I'm sorry. So I lived in this house for 33 years with my wife that I was married to for 52 years.
That part I heard. You may recall I asked you how much square footage and what neighborhood it was in.
Right.
So if you'll go on to after that, you also said that you litigated cases. You said that you've been practicing for the 52 years. So let's go on to this lease.
Okay. So basically, I can't get my pictures to you because they're on my office computer and I am on my laptop. So I'm having a little trouble moving them over. So I guess I'm going to have to just do this without it. So when I moved out, the side of the hill was rough. It had grass and weeds and bushes and stuff. So I decided to make it nice. I would get a landscaper who had been my client for many years and was very competent. Her name was Nancy Brown. And she put that soil and barriers and plants, so it looked really nice. And you saw the picture of that. Well, when they moved out, it was all gone. And the plastic that she put underneath to keep the weed barrier that's what was sticking out. The bushes that I had were in perfect shape when they moved in. When they moved out, they were completely gone and dead. So I had to hire somebody. So I was getting ready to rent it out. The lease says, and you have a copy of the lease they introduced. Originally it said that they were to pay for any repairs not caused by me. That's why I reduced it. That means any repairs that occurred during the time they rented the house, they were responsible for fixing. They saw the house. They knew how old it was. They knew what condition it was in. They knew what the air conditioner looked like, and they agreed to that.
So let me ask you real quick. If there's a freeze and the freeze kills off some plants, are they responsible for that?
They're responsible to cover the plants and the bushes when a freeze is coming. And I sent them an email and said, please, the freeze is coming, please cover the bushes. They were also required to water the lawn twice a week. If they did that, the side of the hill wouldn't have gone away, the bushes wouldn't have died. I'm not
Let
suing
me
them.
ask you real quick, since you brought that up. Aren't the restrictions right now only allowed for once a week?
Well, I lived there when they had restrictions like that. It wasn't all year, but yeah, there
Oh,
was.
but you said twice a week. So I
Yes,
mean, I just
because
want
you
to
use a
clarify.
hose. You use a hose. It's your property, and it's drying out, and you can only use your sprinkler system once a week. You get a hose, and you water the lawn, and you water the bushes, and you water the side of the hill with a hose. That was completely allowed. The lease says they have to water twice a week. They didn't do it. She told me she wasn't doing it because the restrictions, but she didn't. They were supposed to tell me in writing, which they didn't do, and that's a violation of the lease. Also, the lease allows me to make repairs at any time. If I want to go into the house to make repairs, I have to give them notice. I did send her an email the day before we came and told her I'm coming with the landscaper the next day. I came there and I knocked on the door and told her we were there and asked her if it was okay to go ahead and do it. And she said, yes, it's fine. And she went back in the house. And so we did it. And what we did is we put in rocks there instead of soil. We did do it differently. But my landscaper, Nancy Brown had died since in that year. And the new landscaper was also an old client of mine and represented his family for many years. And he was a very reasonable person. And he told me that it was cheaper to put the rocks in than to try to put new soil in and bushes. I didn't replace the bushes. They had to pull them out. They had to like pull out the one little bush that was sitting there and pull out the roots and everything. But I could have put in new bushes and charged them for it, but I didn't because it was already costing more than their security deposit to make the side of the hill back in a condition where I can rent it out. So that's what we put the rocks in. They were cheaper than I was told they were cheaper than putting in the plants, and I was trying to save them money. And there's a side of the yard that is along the property line. And before they moved in, I cleaned out all the limbs that fall from the trees and stuff because if you leave them there, then water accumulates and it gets moldy and animals live there. So you have to clean that out. So when they left, there was, again, twigs everywhere. That had to be cleaned out. So if you look at the bill, I wish I had all my exhibits, but I'm sorry I don't. If you look at the bill, you'll see that it was this the, that all- that he they put in the rocks. The barriers were there before. There were barriers there before to hold in the soil and to hold the side of the hill. So they put barriers back in, and the charges were $6,600 to clean up where the bushes died, clean the side by the lot, and put the side of the hill back in shape it should have been. If they had watered twice a week, like they were required to do, there wouldn't have been any problems here. The bushes would still be alive, and the side of the hill would be fine. They had, in order to exercise reasonable care in maintaining the yard, they were required to cover, and I sent them an email saying it's going to freeze. Please cover the bushes and the side of the hill, and they didn't do it, and that is negligence to not cover bushes. I don't know. I owned the house for 33 years, and nothing like this ever happened. Those bushes had been there 15 years already. And so through many freezes and many times where sprinklers were restricted. The side of the hill, he said, didn't have sprinklers. So that had to be hand washed, hand watered anyhow. But you can't just, I know it's hard to do that, and I used to have to get out there and hand water during droughts and stuff, and to keep my bushes alive and the side of the hill alive, and they didn't do it. They just intentionally did not do that, and that was part of what they were required to do. So, and with respect to these items that they're complaining that I said they should fix, that only occurred before the extension. And in the lease, it says that they're responsible for all repairs. Anything that breaks while they're in possession, they have to fix it. So I told them when they said something broke, I said, well, you're supposed to fix it. When they complained, I didn't, this is the opposite of bad faith. I said, okay, well, I know you're obligated to do it, but I really don't want I don't want to fight with you. You've been a good tenant. They paid rent every month, and I thought they were pretty good tenants. So good that I never went by there for a whole year, almost a year and a half. I didn't see what was happening to the side of the hill. They had an obligation to notify me that the bushes were dying and the side of the hill was falling or dying, so that I could go in there and fix it and not have to replace the whole thing. They failed to do that. That caused damages under the lease also.
By the time they do all the work at the house, when they going to have time to go to work?
But to say,
Mr. Cohen, what was the value of the bushes that died?
oh God, I don't even know. I put them in 10 years ago, and I didn't replace them because I didn't want to have to charge them more than I already was going to have to charge them. And I decided not to ask him for more than the deposit and to keep it.
The problem is he never asked. He took the deposit.
Keep the deposit. And so I was already losing $2,200 on that deal. But I was willing to do it. To say that's bad faith, I'm kind of insulted about that, because I have been a lawyer for 52 years litigating cases. I was counsel to the Senate Jurisprudence Committee. I was the municipal court presiding judge of the municipal court of Rollingwood for 17 years. No one in all that time had ever accused me of acting in bad faith.
No one in this time seen you work Zoom correctly.
And really, I was just, trying to keep it down to the cost down to as much as I could. I fixed that stuff anyhow. And for them to say, oh, I did something I didn't have to do under the lease, and that's bad faith, I think is a little disingenuous. The letter attaches a list of what was repaired and how much it cost. So that the letter does list specifically the items being deducted from the security deposit. So I thought that I had been really a good landlord, frankly, paying for stuff I didn't have to pay for, saving money on the repairs, not charging them to replace the bushes. And, I was going to just keep the security deposit and not ask for any more money. But since they were negligent in not watering the lawn, and they breached the lease by not doing it twice a week, that breach of the lease, according to my landscaper, who has been a landscaper for many years, and his family has been, 25, 30 years landscaping, told me, one, it was cheaper to put in the rocks instead of try to make it the way it was before. And he said that the only way this happens, when the bushes die and the side of the hill falls down like that, is because of negligent maintenance of the yard. So, they thought they were in an apartment or something, I guess. In an apartment, they fix everything and stuff like that. But this is a house. And I lowered the rent. I didn't tell them I had lowered the rent because of this, but I did lower the rent from $5,000 to $4,800 so that there would be enough money in there for the tenants to fix anything that broke. But I ended up fixing it anyhow. And so I'm a little offended that by being, fixing stuff I didn't have to fix. And when I had to fix something, fixing it for less than I could have paid to fix it. And only asking for, You know, the security, keeping the security deposit and not asking for the other $2,200. Call that bad faith is, you know, a little disingenuous, I think. And so I am asking now, you know, for all the money that I had to spend to clean up the side. I didn't charge them for anything in the house except to remove shelves that they didn't get permission to put in, which is a breach of the lease. And so I had to remove them and haul off the shelves. That's what the haul off thing. It's all on the same bill for removing the shelves. It's only like $370 or something like that. But I like again, I did not charge them more than it cost less. I charged them less than it cost me to remedy their failure to comply with the lease requirements, to water twice a week, their failure to notify me that there was a problem with the bushes in the side of the hill so that we could discuss it. And the lease requires them to, if they want to sprinkle water less than twice a week, they had to get permission from me in writing, which they don't have. So the fact that they didn't want, I mean, a hillside doesn't like completely go from what is the picture you saw when they moved in to what it looked like when they moved out. I mean, it just doesn't happen unless there's some kind of negligence in maintenance. I know this because I lived there 33 years and maintained that yard for 33 years. And nothing like this ever happened when I was maintaining the yard. So I think I should keep the security deposit and have a judgment for the difference between what I paid to clean up the yard and fix the yard up. And for, I think it was $2,300.
All right. Mr. Petrie, do you have any questions of Mr. Cohen?
No, Your Honor, but I would like to respond to a few of his statements.
Well, you want to ask it to him in the form of a question or?
Sure. Mr. Cohen, are you aware of section 92.104 of the Texas Real Property Code that requires the burden of proof on the landlord for the retention of any security deposit and for proving that it was reasonable?
Tell you the truth, Mr. Petrie, I was counsel to the Senate Jurisprudence Committee when that law was enacted. So I'm very familiar with it. Also have litigated it on behalf of landlords and tenants for 50 years. So yes, I'm familiar with it.
Okay, great. Well, I haven't seen any photos of the property. You say that the house was in pristine condition. I provided the photos. Do you have any evidence showing that with the condition of the yard when you moved out?
No, I'm not complaining about the house. You did a really good job of cleaning the house. I'm not complaining about the backyard. It was messy. When I lived there, I left it as a wild area. So whatever you said about the backyard, I'm not disagreeing with. I'm not talking about anything except the dead bushes, all the dead stuff on the side of the street, the loss of the landscaping on the hillside, and cleaning up the lot line between my lot and the next door neighbors. That's what I'm asking for. And all this other stuff is fine. You were good tenants. You paid your rent on time. You cleaned the house very nice when you left. You just didn't want to go through the effort of hand washing my yard and protecting the bushes from freezing and the side of the hill from freezing. I know it was a lot of work. I had to do it all the time. It's not easy. But you didn't do it, and that's why I had to spend the money. I'm not, you know, I wouldn't do it any other way, and I did not charge you for any or claim that you had to pay to fix anything after the extension was done.
Well, let me ask you this. So you mentioned, you know, in terms of evidence, again, you don't have any photos showing the condition of the property, but you also cited that that you sent a note saying that we needed to cover the bushes. I don't recall ever seeing a note like that. Do you have evidence that you did that? Because I know you told us to cover the pipes. Never heard anything about bushes. Do you have any evidence about that?
I told you to cover the landscaping because it was going to freeze.
What were they going to cover it with? A heated blanket?
Do you have that? Did not get any notes about which needed to be.
I have an email of that to that effect. I'm sorry. I didn't realize that I was going to have to present it from my files. I thought when I sent it to the court, it would be available for me at the Zoom hearing from the court to show the court. I just misunderstood how it was going to happen. So I don't, and so the laptop, my office computer does not have a speaker or a camera. So I have to always had to do Zoom. I had 3 Zoom trials during COVID, and I always had to do it on the laptop. So, but when I sent the exhibits into the court, I misunderstood. I thought that I could just ask the court to put them up so the judge could see them. The judge has them. I just don't know. Huh?
Boucher, do
Well,
you
let
have
me.
an email? Hold on. Boucher, do you have an email that you can find? Mr. Cohen, what would it be identified as?
Well, I got acknowledgments from the court for all of them. They sent like 20 emails with 20 exhibits, and the court's got them all.
Okay.
I just can't get to them today because they're on
What
my.
is it? What is it titled, Mr. Cohen? Like what am I looking for?
It was on the correspondence I got from you. It said email in all the exhibits. So
Look under defendant's exhibits.
yes,
Right, but there's several. There's a lease, there's extension and modification of a lease. There's a vacation letter. Is it
yeah.
the
There's
51
20.
page?
There's 20 of them, and if I have them by number, but and I can describe them to you, but if I
Is
don't have,
it the 51? Sorry, is it the 51 page document?
it's 20 separate emails. Each one has a separate exhibit. And I sent to you, and I can figure that out in a minute. Let me see.
I'm gonna open the 51 page and see what that is.
Yeah, let me
And is it because I see combined documents here. You said it's an email.
yeah, I sent 20 emails,
Right, and that's
separate exhibits.
unfortunately that's
Well,
not
I misunderstood because you wanted me to send you the exhibits. Normally in the trials I did, I would have this all set up so that I could show the exhibits during the trial. But since you asked me to send them to you, I thought you would have them available to show during the trial.
That's correct. I'm just trying to locate it for you since you have so many.
Let
What I'll
me,
do, Judge, I'll share my screen for the 51 pages and we'll see what's in it.
all right.
I'm looking at one right now that it shows the very first picture is the picture of the side of the cliff.
If you can tell me the
Yes.
exhibit number, I'll know exactly what it is.
And then everything else after that is the lease, the
Exhibit number
inventory of
9.
the property.
Can you show exhibit number 9?
So none of them were labeled that way.
On the bottom
Um,
they were. So if you open up, it'll be in order. I sent them in order. Exhibit 1 was the first email. Exhibit 2 was the second one. Exhibit 3
oh,
was
Your
the
Honor, I
third.
see it on page 40 is exhibit 9.
Okay.
Okay, I can't scroll through this faster.
Okay.
And
I can share for you, no problem.
Okay, thank you. Exhibit 9 would be my first exhibit.
Give me a second. And then I'm gonna try to make this bigger because you might not be able to see my whole screen. Hold on. I can't move this top part here.
That's exhibit 9. Your Honor, that is a picture of the side of the hill when I moved out. That's what it looked like.
okay. And if you look at page 1, I think of the same exhibit, it shows what it looks like now.
What it looks like now is so anyhow, what the next exhibit would
Or at move out right there. So
yeah,
that's the
that's
same
the
hill we're
side
talking about.
that's the side of the yard. That's where the twigs were when I had to clean them out. You can see all those twigs over there on the side yard.
Right.
Yeah, so I had to clean all those out.
Right.
So
This isn't
if
the
you
same
look
But that is
picture.
not the same as a picture from page 40.
no, it's a different part of the yard.
Okay, what does the picture on page 40, what does that look like at the time of move out?
Okay, so where are we? That is what it looked like when I moved out.
All
Okay,
right.
all right. So
Now, when they moved out, where would we find?
If you can look at exhibit 11, 12, and 13, That's what it looked like when they moved in.
All right, I just can't see the page number. I'm trying to move this
Well, I
statement.
see
Okay.
exhibit 12.
11,
Let me go
11,
back.
12, and 13 is the way it looked like when they moved in.
Go down, Riche. So that's exhibit 9. Go down. There you go. So this is
11.
okay. So this picture and the one on exhibit 9 does not look like the same yard. It looks like the same wall,
Yeah.
but that
No, but
completely grown
that's the
in
way it
versus
looked.
the other one.
Yeah, so Your Honor, this is the way it looked when they moved in. So
Okay, so hold on. This is when they moved in. So let's go to
Yes.
exhibit 9.
Exhibit 9 was when I moved out. So I cleaned it up to make it look nice and put in all the soil
Okay.
that you see in exhibit 11,
Well,
12.
let me see what it looks like when they moved out.
And when they moved out, if you'll look at exhibit number 14,
Riche, if you'll scroll down.
yeah, there it is. That's what that yard looked like when they moved out.
These
Okay.
were different times of the year. What time of year was it when you took that first picture and when you took this last picture?
The first picture was right before you moved in. I can't remember when that was. And this picture was right after you moved out, like in January.
That's not because they replaced all of that with river rocks in
No,
January, and we
this-
moved out in February. So this is not when we moved out.
Well, this is before, okay. This is when I went there and before I put in the river rocks, this is the way it looked.
This is the month before they moved out.
Month before they moved out, yes, sir.
Okay.
And so then exhibit 15 is the side of the yard after they moved out. It's all, I mean, no, wait a minute. This is the bottom part of this of the yard in front of the street.
Yeah, these are lantanas that are dormant in January. That's why they look brown.
Yeah, yeah. I'm just saying that's what it looked like after they moved out.
Is it the lantana that had to be removed?
Some of them had to be moved because they were dead. Some of them stayed.
But are we talking specifically about lantana?
I don't know what they were. Some of them were lantana. You see the one on the right up there is a different kind of plant. That's
One on the right is. The one on the left looks more like it's a very large grown lantana, but because it's
yes.
wintertime, it will die off in the winter, but they do come back.
Yes, sir, I know. But they had to be cleaned up because it wasn't maintained. The lantanas were not trimmed or taken care of. So it was wild and it needed to be trimmed. So I had to have that done. If you look at exhibit 16, yeah, that's the bushes before they moved in.
This was probably in May, and we moved in September, and the yard was in pretty bad condition when we moved in. So this is not at move-in. We moved in August, and this was May. So
Whatever.
the yard did not look like this when we moved in, as noted in the lease condition report.
Excuse me. I'm talking right now.
Well, I'm starting to feel a little heat.
This is what it looked like when I moved out. Okay, then if you look at exhibit 17, where's 17? There, where's the bushes? They're all dead except for that one on the right.
All right. Anything else?
If you look at exhibit 19, do you have 19?
That's
It might
18.
be separate because that's
18 is what this area looked like when they moved in.
All right.
And 19.
So, Mr. Petrie, any objection to these photographs being entered into evidence?
My only objection is the date. He's claiming they're move in and move out, and those aren't true.
But there's
the
no
pictures
objection as
themselves,
to the photos on what they represent on the dates that they were taken.
no objection.
Okay, so they'll be entered.
And then if you look at 19, that's the yard, that's the side of the yard on the lot line no, I'm sorry, 18 is the way it looked when they moved it in, And 19 is the way it looked when it moved out. So I had to clean all those twigs up again.
Well, 18 looked like it was pretty empty. So,
Yeah, that was after I cleaned it out when I moved out. So I cleaned it up when I moved out, and then 19 was the way it looked when they moved out.
all right.
So
Is there anything else? Because we've taken up quite a bit of time on this so
no,
far.
no, that's I mean those. So you see the difference. When I came there like a month before they were leaving, I saw my yard that I had spent $8,000 on completely gone. Everything I spent $8,000 on was gone, and my bushes were dead, gone. So, I had to spend money to fix that. I had the right to go in and repair it anytime I wanted to. And then the notice of that provision is if you're going inside to repair, so you're not bothering them, okay? But on the outside, I sent an email, said we were coming. I came, I knocked on the door to make sure it was okay because I never heard back from her. And I guess she was real busy, and she said fine, and she left, and she closed the door. We talked for like 5 seconds.
Okay.
And so we went ahead. If she would have said, no, don't do this now. I need you to wait till after we move out. We're going to fix this up some. I would have left. I would have been so happy if that was the case. But obviously they had failed to maintain my yard, to use reasonable care to maintain my yard for a year. They didn't cover the stuff, even though I emailed them before the freeze, said, please cover all the bushes and the side of the lawn. It's protected from the freeze. Water twice a week, please. You have to water twice a week. The landscaper told me that the bushes were dying. You have to water twice a week. They didn't. They just didn't do it. And they intentionally didn't do it. They knew, they were informed you have to do it, and then they refused. So, it's negligence is intentional.
All right, Mr. Cohen. All right. So I think I have enough information to make a ruling. These types of leases, anytime that you have a lease, as both parties are aware, there is a requirement that the landlord issue an inventory or an itemized list within 30 days of move out or possession of the property on what is being retained as far as the deposit, and that has to be done. This court's a little bit different than other courts in that the rules of civil procedure don't apply here like they do in the other courts. And so that means that as judge, I have a lot of leeway that I can interpret certain types of things. That's also the reason that I get to ask questions in this court when typically you never hear judges ask questions of witnesses. This court is different. And so I'm able to do those kinds of things. And you heard some of those questions that I asked. With respect to the invoice that was sent out, I think that it's sufficient to satisfy as an inventory within the 30-day requirement. The move out I asked was 2/15. The date of that letter was 3/15. That's within the 30 days. So I will treat that as a notice. There is a requirement to itemize specifically, what it is that you're pulling for. Mr. Cohen, what you did basically said, I had to do all of these things because of them, and therefore all of it is the cost. I don't believe that any type of repairs that you do or upgrades that you do can be included in this. That goes for wear and tear, any of those type of things. Yards can go through wear and tear just as the interior of the house can go through wear and tear. And so I'm just not simply going to accept that a blanket, it cost $8,000+ to do all these things, and therefore they need to pay it. Mr. Cohen, you know as well as I do that waste in real estate can also mean improvements, right? Because if you do something to a property that improves upon the property, but it's not the same as it was before, right? If I go in, and this is more common in a commercial lease, but if I go in and I take a commercial lease and I decide, you know what, I want to build a really nice kitchen in this area because this commercial lease doesn't have one. When I move out, it certainly improved that property, but if the landlord can't rent it out to somebody else, with that kitchen in it because that's not something they need or want, it's considered waste and you need to put it back to the way it was. So when I look at things, for instance, like the shelves, those type of things, if you need any type of those type of improvements, that can be considered waste, even though it's an improvement upon the property in your mind. And so these are all the factors that I'm looking at. The reason, Mr. Cohen, you reduced the rent is because you couldn't get the $5,000 a month in rent. Okay, you mentioned that yourself. So it's not that I lowered the rent because I wanted them to take care of the property, because if that were the case, that would have been in the lease. And you know that as well as I do, and that's not in there. The lease was reduced because that's what the market rate was for. I asked about where this property was, what's the square footage, to determine if the $4,800 a month was reasonable or a market type rate, which it appears that under the circumstances that was. Could you have gotten more? Maybe. Could you have gotten less? It could have been. But in this case, this particular couple is willing to pay the $4,800, and so that's the value of the lease. It has nothing to do with, well, they got to pay for anything. It's a little too broad to say if anything goes wrong with the property, they're responsible for it. I think in a commercial lease that you're going to have some grounds to be able to do that. That's why triple net is put into place for maintenance, for insurance, for taxes. But that's not the case with a residential lease. And so just because something goes wrong doesn't mean that the tenants are therefore responsible for everything that goes wrong in a property just because it happens to be at the time they're there. I've had people where they had to replace a carpet because it was in kind of bad shape when the tenants moved out. But the tenants were there 1 year and they had owned the property for 12 years and it had all the wear and tear for 12 years and they wanted the cost of the entire carpet. It just doesn't work that way, right? And you know that as well as I do. Now, is there bad faith on the part of Mr. Cohen? I don't believe so. I don't believe that there's bad faith. I think that he paid money to upgrade his landscape before he left or before he rented it. And he went in to do some upgrades to it after the fact. Now, are you responsible for all the costs of those upgrades? Absolutely not. If he's upset about bushes that have died off or something, he has to at least give you some type of demand or something to say before the fact, you need to repair this and give you an opportunity to cure that. You never had that opportunity because you hadn't even moved out yet. Is that bad faith? No, it's not bad faith. That's just him being proactive and going in there and taking care of it. But with that said, Mr. Cohen, you cannot charge them the full amount of the landscaping just because some bushes died. It just doesn't work that way.
I agree.
And
no, it's okay. Go ahead. I'm sorry.
you just can't do that. You know that. You can't do that. That's another reason I asked the question, what's the value of the bushes? Well, we don't know what the value of the bushes is because I have no evidence to determine what that value is. We talked about the lantana. Lantana is intended to grow wild and to overgrow and be as a bush because the more you trim it, the bigger and more wild it's going to get, right? And it does go dormant in the wintertime, and that's very common. I have lantana here in Austin. When I lived in El Paso, I had lantana. Heat causes it to grow a certain way. Just because it looks bad in the wintertime, though, does not mean that it's dead. And without a value or some type of testimony to show that, in fact, that it's damaged in some way, that I can't grant any type of judgment in favor of replacing for something that I don't know what the value is. And you opted not to replace it. Could you have replaced it? Absolutely, you could have. Is there value in it? Yes, there is value in it, but I don't know what that value is. We do know that there was an invoice of work that was done through Dynamic Touch for $378. That was done after the fact. That was for the removal of branches and twigs and wood and other kind of stuff, some debris that was left in the yard, natural type debris. It's not like it was trash. But the removal nonetheless was required. There was removal of some shelves that were put up that, according to Mr. Cohn, they did not have permission to do so. Mr. Petrie, you acknowledge that you put those shelves up. Regardless, those needed to come down. There was some repair to silicone done into the shower. There may have been some issues. We're talking about mold here, potentially. We're not talking about just regular wear and tear. This is for care. So I think that under the circumstances, certainly the invoice for the $378 is a valid claim to be reduced from the deposit. The deposit was $4,800. I'm going to subtract the 378. That's 4422. That'll be the amount of the judgment in favor of the plaintiff. The counterclaim is denied at this time. All right. Thank you all very much. Good luck to
Thank you, Your Honor.
Thank you, Your Honor.
Well, I can say that the pro se plaintiff did a good job of representing himself and presenting the evidence in the case. The attorney, however, he had some misunderstandings, so that's understandable. I don't think he used Zoom a lot, but he didn't have his evidence, but the court was able to bail him out towards the end. But I hope you enjoyed the video. Give it a thumbs up if you did, and I'll see you around on the next one.